Okay, so that was outsider confidentiality. Tell us a little bit about insider court confidentiality.
Insider court confidentiality, remember, is about the extent to which evidence from the mediation room is admissible in subsequent proceedings, right? Such as statements or documents produced in or for the purposes of the mediation. Most of the litigation that occurs in relation to mediation involves this aspect of confidentiality, insider court confidentiality. And typically you've got a scenario where you have one party wanting to enforce a mediated settlement agreement and another party challenging that mediated settlement agreement. For example, by saying, well, it's not valid because we didn't sign off on it properly, or it's not valid because you engaged in a sort of misrepresented your product or something upon which I relied, and so I don't need to fulfill on this contract. A typical contract sort of contract defence. So then a court has got to decide, to what extent can we look inside the mediation room? To what extent can we, if you like, lift the veil of confidentiality and have a look into what happened in the mediation room in order to prove the allegations, for example, of misrepresentation, or to see to what extent this mediated settlement agreement is enforceable or not. Okay, and this leads to another point. It's a very tricky area because it leads to another point, which is about accountability. Some people say, confidentiality is everything and it has to be absolute in mediation, right? But if confidentiality was completely absolute, it'd suffocate the mediation process and people could do whatever they liked inside the mediation process. You can't use the process to hide bad behaviour or hide illegal behaviour, for example. Right, so it needs to be able to breathe a little bit. Right, you still need to have a confidential process where people can rely on its confidentiality. But if someone is seriously alleging that there was fraud or misrepresentation in the mediation room, or if someone, for example, is alleging that their mediator was biased, for example, then there's got to be a way to deal with that. Right. And so for that reason, it's the most litigated area because you're dealing with the enforceability of settlement agreements. To what extent can you admit mediation evidence from the mediation where the general rule is that you can't, right? But there need to be some exceptions because it's about balancing the integrity of the process with the accountability of the people who take part in it.